Let's be honest, there are few things that cause that sudden jolt of anxiety quite like an unexpected letter from HMRC. And what if it's a penalty? Well, don't panic. In this guide, which we've developed with the absolute experts at My Tax Accountant, we are going to break down exactly how you can challenge that penalty, step by step. You know the one I'm talking about, that dreaded brown envelope lands on your doormat. Your heart does that little flutter as you spot the HMRC logo. You open it up, and there it is, a penalty notice. It's a moment that can feel incredibly stressful, really confusing, and let's face it, maybe even a little bit unfair. But look, the very first and most important thing to do is not to panic. I promise, there is a very clear, well-defined process for appealing, and just understanding it is the key to taking back control. The brilliant team at My Tax Accountant has helped us map out this entire journey so you'll have the clear, professional advice you need to navigate it.
So here's our roadmap for today. We'll start with why you even got that penalty. Then we'll figure out if you've got a solid case. We'll walk through that first appeal, what to do if it gets rejected, and even how to escalate it all the way to a tribunal if you need to. And then finally, we'll cover your next steps. Ready? Let's get into it.
Okay, so let's kick things off right at the beginning, figuring out why that brown envelope showed up in the first place. Because honestly, knowing the why is your first step to building a really successful appeal.
Right. So according to HMRC, there are 4 main culprits here, or what you could call the 4 big traps to avoid. The most common one? Sending a tax return late. That's an immediate 100-pound penalty right off the bat. Close behind is paying your tax late, and that's where penalties and interest can really start to stack up. But you can also get penalized for sending in an inaccurate return, especially if HMRC thinks it was careless or, worse, deliberate. And finally, a less common but still serious one is failing to keep good enough records to back up your figures. Pinpointing which one of these applies to you is absolutely crucial for your appeal.
Okay, now for the most important question of all. Do you actually have a case? Well, this all comes down to one critical idea: having a reasonable excuse. To make this all feel a bit more real, let's follow an example. Let's meet Sarah. She's a freelance marketing consultant based in Manchester. She's brilliant at her job, normally super organized, but last month her father became seriously ill. In all the chaos of hospital visits and family stress, she completely missed her self-assessment deadline by a week. And now she's got a £100 penalty notice sitting on her kitchen table. So does she have a case? Let's find out.
The million-dollar question, isn't it? What does HMRC actually count as a reasonable excuse? Well, it's not just any old reason. It has to be something pretty significant and unexpected that genuinely stopped you from meeting your tax obligations on time.
Okay, I love this slide because the contrast is just so clear. On the left, you've got these serious, unforeseeable events, an unexpected severe illness like what happened with Sarah's father, or a fire that destroys your records, or even MHRC's own website crashing right on deadline day. These are likely to be accepted because, they're outside of your control. But then on the right, you have the reasons that HMRC pretty much sees as your problem: forgetting the deadline, not having enough cash to pay, or relying on your agent who then messed up. Those just won't fly. And then you get my personal favorites, straight from HMRC's official list of rejected excuses. Your goldfish died, or a witch put a curse on you. Seriously. So the big takeaway, it has to be serious, unexpected, and something you couldn't have reasonably planned for. And here is a pro tip that catches so many people out. The deadline to appeal does not start from when the letter hits your doormat. It starts from the date that is printed on the penalty notice itself. This tiny detail can make all the difference, especially if the post is slow. So check that date immediately. You have just 30 days. 30 days from that date. That is your entire window to act. If you miss it, you'll have to provide a really good reason, not just for the original mistake, but also for why you were late in appealing. So the second you get that letter, the clock is officially running. Stay with me. The next point might surprise you.
All right, so now you know you've got a case. It is time to take action. Let's walk through how you actually launch your first appeal directly with HMRC. This is the stage where, honestly, clear communication and solid evidence can get the whole thing sorted without any more drama. Now, before we dive into the nitty-gritty, this timeline gives you a great bird's-eye view of the whole potential journey. It all starts with the penalty and your 30-day window to appeal. HMRC will then review your case and give you a decision. If they reject it, you can escalate to something called a statutory review for a second opinion inside HMRC. And if that doesn't work, your final stop is the independent tribunal. It's a clear path, but you've got to follow the steps in the right order.
So let's break it down. Your first appeal has 4 key steps. Step 1 is absolutely 100% non-negotiable. You must fix whatever caused the penalty in the first place. So if it was a late return, you have to file that return. HMRC won't even look at your appeal otherwise. Step 2, gather your proof. For our friend Sarah, this would be a note from her father's doctor or the hospital confirming the dates of his illness. Step 3 is to formally submit the appeal, either through your government gateway account or by post using Form SA-370. And finally, Step 4, you just have to wait for their written decision. But what if HMRC rejects your appeal? Don't worry, it's not over. Your next move is to escalate to a statutory review. And that's not all. Here's where most people go wrong. They get that first rejection letter, they feel totally disheartened, and they just give up, accepting a penalty they might not even have to pay. So what on earth is a statutory review? Well, it's basically your legal right to have your case looked at all over again, right from scratch, by a different impartial HMRC officer who had zero to do with the first decision. Think of it like getting a fresh pair of eyes on the problem. It's an independent review within HMRC, and it's completely free. It's a really vital safeguard that's built right into the system. The process itself is pretty straightforward. Once your first appeal is rejected, you have to formally ask for the review. HMRC then has a 45-day deadline to get back to you. They'll come back with one of 3 possible outcomes. They can uphold the original penalty, they can vary it, which might mean they reduce the amount, for example, or the one you're hoping for, they can cancel it completely, wiping the slate clean. Okay, so you've had the review, but HMRC still won't budge. Now we're entering the final and most formal stage of this whole process, taking your case to the tax tribunal. This is a big step up, and your approach really needs to change to match it. Now, this is a real game changer. The first-tier tax tribunal is not a part of HMRC. It's an independent court, part of the official UK courts and tribunals system. What that means is your case will be heard by an impartial judge, which guarantees a fair hearing that is totally separate from the people who gave you the penalty in the first place. For a lot of taxpayers, this is a hugely reassuring fact. Right, so this isn't just sending another letter to HMRC. This is a formal legal process. That 30-day deadline from the review decision is really strict, and you'll need to present a very robust case with strong evidence. This is exactly why success at this stage often comes down to expert preparation and legal representation. It's also good to know that you can consider something called alternative dispute resolution, or ADR, which is basically a type of mediation with HMRC before you get to the hearing. It can be a much less confrontational and less expensive way to sort things out. Phew! We have covered the entire journey, from that first brown envelope all the way to a final tribunal. So let's bring it all together and talk about how you can take control of the situation and move forward with some real confidence. I think this quote just perfectly sums up the reality of that final stage. The tribunal is a vital safety net for taxpayers like Sarah, but it's not a casual chat. Success really demands thorough preparation and, ideally, expert guidance. It just highlights how important it is to get things right from the very beginning to build the strongest case you possibly can. Okay, before we finish up, a very important note. The information in this guide is for general purposes only, and it's accurate as of November 2025. Tax is complicated, and everyone's circumstances are unique, so you really shouldn't rely on this exclusively to make financial decisions. Before you take any action, you must consult an expert. And really, that's the final takeaway. You do not have to go through this alone. The process can be tricky and the stakes can be high. The experts at My Tax Accountant specialize in handling HMRC penalty appeals and all sorts of other tax issues. They can make sure you build the strongest possible case and get it right the first time, giving you some much-needed peace of mind. You can reach them by phone on 020-8570-8531 or just drop them an email at info@mytaxaccountant.co.uk.